The first time when there was a conviction, it pierced my heart.
Hello, everyone, and welcome to Inside the Matter. My name is Am Kadima. I'm a partner at Aurora Company Advocate, and today I'm joined by our senior partner, who I would like to introduce himself.
Thank you, Anne. My name is Chacha Odera. I am the senior partner in the firm of Aurora and Company Advocates.
You've just referred to yourself as Chacha Odera and not senior counsel. Why don't you introduce yourself as senior counsel?
Well, I think the title senior counsel is a conferment, and it is a recognition by my peers of the status they've conferred upon me. So I am happy to call myself Chacha Odera, but happier when my peers refer to me as senior counsel.
Great. I like that. It does embody one of the pillars or one of the values of our firm, which is humility, and we can see that coming through. Before we jump into discussing what is actually the theme of our podcast, I would like you to take us a little back. Maybe tell us a bit about yourself. What made you pursue the law career and your early years as a young lawyer?
That's a very interesting throwback. We were the class that graduated in December 1987, and we then had to go to the Kenya School of Law, which at that time was a one-year program. 3 months of it was spent under the pupillage program, chambering in various law firms, and the 9 months was 9 months was pupillage, chambering in various law firms, and then 3 months was class. We were a class of probably just slightly over 60 or 70. I can't quite remember the numbers. But as was the tradition then, the Kenya School of Law was big enough to accommodate the number of students that it's taken. And by saying accommodate, they not only accommodated them in class, but also accommodated them by giving them residence. So the training was not just how one is supposed to conduct oneself in a law firm. It went beyond that. Our then principal was an old Englishman called Tudor Jackson, who insisted that at all times, whether in the school or out of the school, we had to conduct ourselves as lawyers. And indeed, you will recall from professional ethics class, a lawyer or an advocate is expected to conduct themselves in a manner that does not bring disrepute to the profession. So it was a wholesome training. My first employer, I'd been offered a job by the law firm I was doing pupillage, but they offered me transactional work, which was probate and administration. This was Daly and Figgis. At that time, they prided themselves to have been the oldest law firm. I was not particularly enthusiastic about probate and administration because, as I saw it, I was dealing with people who are either anticipating death, so they would come and instruct us to prepare a will for them, or people who had died, in which case we would be preparing the various petitions for probate or letters of administration. My idea of law was that one goes to court, one litigates in court, and having stayed in Daly and Figgis, probably just less than a month, I came across Governor James Orengo, who offered me litigation practice. And Governor James Orengo did a lot of work at the criminal bar, and he also did a bit of work in constitutional and judicial review division. So I then went to work for him for a period of about 9 months before moving on to Oraro and Rachir Advocates. That would have been in 1990. And I was placed directly under Mr. George Oraro, who's our founding partner.
Maybe you can tell us a little bit more about your working relationship, especially in those early years as a young advocate with Mr. George Oraro, our founding partner.
Well, I was one of those beady eyes, probably naughty young lawyers who wanted to apply the minimum effort, but hoped to be rewarded with maximum reward. But Mr. Oraro was, I must say, he did quite a good job in railroading me to appreciate that the most important thing in practice was to excel. And upon excelling, the reward will be consequential. You know, many a times we have people who come out, you ask them, why did you choose a career, whatever it is, whether it's a lawyer, an architect, an engineer, they will tell you, because I wanted to make money. But when I met Mr. Oraro, he changed my mindset completely. He emphasized on the need to excel. And by excelling, the rewards by way of compensation will be consequential. And over the years now, when I think about it, probably 38 years in practice, he was very right. I have come across many professionals who set out to make money as quickly as possible. And indeed, some of them have fallen by the wayside. And at the end of it all, those professionals have been able to say that, yes, I have made money, but few of them can say, yes, I have excelled. But on the other hand, I have come across many professionals too, who set out to excel. And it took time for them to get to what one would call the peak of their career. But at the end of it all, they excelled and they were handsomely rewarded. So at the end of it, if one is to pay tribute to those professionals, one can say they not only excelled in their careers, but in their careers, they did leave a legacy behind and mentored many who came after them.
We have seen that you have been throughout your career, started at Galleon Figgies, moved on to work with Governor James Orengo, and now from 1990 at Oraro and Rachir, which obviously now is Oraro and Company. What's the reason that made you stay at Oraro? Are there times you wanted to just up and go?
Yes, as a young man, I was very restless. And one thing about my early experience is that we all came out of university, went to the School of Law, joined the profession. And one thing that we were never taught is patience. And at Oraro and Rachir, and I must say I was very fortunate to work under Mr. George Oraro, who, whereas he was extremely, he was a person who exerted the best out of you, but he also explained to you why he's doing so. And it is as a result of George Oraro not accepting a resignation which I gave him sometime about 1991 that I am still there. And indeed, I'm still waiting for his response. What had happened is that it was a Friday, I recall. We were working under a lot of pressure in the days or weeks preceding that Friday. And that particular Friday, I'd spoken to a couple of my friends, and I told them that, look, I am quitting. And indeed, we had spoken with some two other young lawyers, and we had agreed we will start a law firm. So on this Friday, I drafted my resignation, put it in an envelope, and spent a good part of the day still wondering how I will share or how I will deliver this resignation to Mr. Oraro. So after everybody had left the office, I walked into his office and I gave him the letter. He didn't open it. He asked me what it was. Then I told him it is my resignation letter. He didn't even ask me why I was resigning. He took that letter and threw it in the bin and told me to sit down. Then he looked at me straight in the eye, told me that I know why you are contemplating leaving the farm, and I will not let you leave the farm. He then picked a rubber band and started stretching it. And he told me, this rubber band, the value of it is how much you can stretch it. Similarly, your value is how much you can stretch your potential. He then went on to tell me that he can see a lot of potential in me, which is untapped and unutilized. So I may think that he is unfairly exerting pressure on me, but what he's doing is stretching me to my full potential. And without saying much, he pulled a file and told me he wanted an opinion before I go home. And this was at around 5:30, 6 o'clock on a Friday. And meanwhile, I told my buddies that let's meet at the carnival. We have a celebratory drink because I'll have resigned. And we can then figure out our next course of action. And here was Mr. Oraro, who was the cause of me contemplating resigning, exerting more pressure on me by giving me work on a Friday evening and asking me that he would like the opinion before I leave. I picked the file, went back to my office. Those days, we didn't have mobile phones. So my friends were waiting for me in Carnival, and I couldn't communicate with them that I was running late. So I looked at the file. I scribbled. Those days, we didn't have laptops. You just had to do the longhand. I went as best as I could, prepared an opinion. And I think it was a good opinion. Then at about 8 p.m., I went to his office. He was still there. He looked at it and told me, let's meet tomorrow at 10 a.m. We review your opinion. So I looked at this fellow and I wondered, tomorrow is Saturday, and you're already telling me you've already stretched my time to 8 p.m. and you're still telling me to come tomorrow at 10 without asking me what I am up to. But all the same, I decided I slept over it, and at 10 a.m. I was there. We reviewed the opinion. He was happy with it. And we never discussed that resignation. And I suspect the letter is still somewhere in some garbage dump somewhere. That was about 1990, 91, about 1991.
Well, I can say that it was a good thing that he did not accept your resignation, because here we are now.
Well, he didn't accept it. Neither did he reject it. The letter remains unreplied to. And indeed, every time in the office, when he tells us that part of our standards is that we must respond to correspondence within 24 hours, I always remember that he still not responded to my letter of resignation that would be about 36, 37 years later. Yes.
I want you to look back into your practice life. And one of the things you said you really wanted to do as a young lawyer was to get into the courtroom. You did not want to be a transactional lawyer. So what can you tell us as the first case you ever did that really left a mark or an impact?
It's interesting. I have ended up today, being more of a lawyer practicing in the commercial division or the employment and labor relations division. But I always remember that at the beginning, I also did some work in the criminal court. And at times, I look back and I appreciate that work that I did in the criminal court helped me in years to come when I completely migrated to the civil division. Because some of this work which you do in the criminal division, there are some which impact so positively upon other people in ways that is difficult to describe. One particular instance I remember is I had an uncle, my father's brother, the late Ibrahim Onyango Ogola, who was the first lawyer in our larger family. And I am the second lawyer. And Justice Eric Ogola is the third lawyer. But today we have, together with the children and grandchildren, we do have probably about 10 to 15 lawyers in the home. But in this particular case, my late uncle sent a client to me. He was practicing in Mombasa, and it didn't make sense for him to take up a case from Mombasa, and the hearing was in Nairobi. So he asked me if I could assist. He sent over his instructing client, who was some Ugandan fellow, and the fellow came and gave me the background of events that led to the arrest of his sister. His sister was a house help somewhere in Parklands, and she was what today is commonly referred to as an undocumented worker. So she was working for this Asian family, and she didn't live within the premises. She would come during the day and leave in the evenings. On this particular occasion, she came in her usual routine to work and found a contingent of police hovering around with a few police cars around, and she realized there was a problem here. And like undocumented workers, she took off. She didn't come into her designated place of work. At about 10 a.m., she came back, looked around, and the place looked clear. And when she came into the premises, unknown to her, there were still some police within the premises, and she was arrested. She didn't know why she had been arrested. It was only later that she learned that the lady of the house had been killed, and she was the first suspect. The brother who was instructing me spent most of our engagement pleading her innocence, which really I was not interested in hearing. I wanted the facts. He didn't have much of the facts. So he asked me if I could accompany him to the remand home, which was at Langata prison. And since I really didn't have time, and this was a pro bono brief, I declined. I told him that we will meet when his sister is brought to court for a mention. On the mention date, I went to the basement of the court cell, or the basement of the court, where the cells were located. And we had a conversation with this lady, the accused person. By the end of our conversation, which couldn't have taken more than 15-20 minutes, I was convinced that there was something about this lady that points towards her innocence. And the challenge was, how do I prove her innocence? Or, as lawyers would put it, how do I poke holes into the defense case. So it does not meet, the prosecution case, so it does not meet the required threshold to secure a conviction. When the hearing commenced, I literally approached it blind, in the sense that I didn't have much material. Criminal cases, by their nature, especially the blue-collar crime, there's no paperwork which you can analyze. It's a question of reconstructing the scene, the events, impeaching the evidence of the witnesses. So that's all I had. The first witness was the deceased husband. He said they had one child who was a school-going child, and as was the routine, he had left the house at 7 a.m. in the morning to drop the child to school. And after dropping the child, he would usually go to his place of business. On this particular occasion, and for reasons he didn't specify in his statement to the police, he came back home. And when he got home, he opened the door, got in, went to the bedroom, and found his wife's lifeless body lying on the bed. And it was at that point that he called the police. And the house help was also not at her station of work. And the first suspect, of course, was the house help. I then started cross-examining the fellow. From the face of it, it looked like he had a very believable story, ironclad, and with very little chance of poking holes onto it. But I started from a very interesting place. And purely out of some gut feeling, I asked him whether his wife was insured, whether he had taken out a life insurance for his wife. He was reluctant to answer that question. And upon insisting and pushing on, he conceded that the wife had been insured. The amount, 5 million shillings. And 5 million, then and as is today, is a princely sum of money. This is way back, probably must have been about 1990. That was a lot of money. And I asked him what his wife was doing to earn a living. He conceded she was a housewife, and that it was him who was the breadwinner of the family. Then I asked him whether he had an insurance policy for himself. Again, he was reluctant to answer, arguing that this case is not about insurance. And I told him, please just answer the question. He reluctantly answered that yes, he was insured. How much was he insured for? 1 million shillings. So then I asked him, okay, if you died, and God forbid, your family, your wife and small child will receive 1 million shillings from the insurance. He conceded yes. But if your wife dies, you and your little child will get 5 million shillings. Instead of answering my question, he started telling me how much he loved his wife. And I told him, yes, I don't doubt that he loved his wife, but that money would not be going to his wife because she's dead. It would be going to him. So he conceded, yes, he would get 5 million shillings. Then I went to the next phase of cross-examination. I asked him whether the house help, who was now the accused, had a key to allow her into the premises, and he said no. And I asked him, when he had left, was the house open? Did he leave the door open? He said no. Then the only way the house help would gain entry to the house would be if either she had a key, which she didn't, or alternatively, the person in the house would open for her. He conceded and he said yes. Then I let the thing slide. Amongst the witnesses who came was a police pathologist who was called to site. I believe it was either the late Dr. Zephaniah, the pathologist, police pathologist was called Zephaniah, or a second one was called Dr. Ngang. It was one of the two. They had come to the scene, and with the police, the scene of crime photographers, he had made his initial observation. When he came, I asked him what time he had gotten to the scene, and he mentioned it must have been about 9 o'clock. And when I asked him his expert opinion on approximated time of death, he said the deceased may have been dead probably for 7-8 hours. This was 10 a.m. in the morning, and he says the deceased would have been dead 7-8 hours. And I asked him why he formed that opinion. And he mentioned that rigor mortis had set in and the body had relaxed. So that would give him an approximate time of death. So the significance of that evidence was that the deceased husband had left the house at 7 a.m. This was at about 10 a.m., which means the deceased husband had left 3 hours before. And going by the doctor's evidence, by the time the deceased husband was leaving the house, the wife was dead. We then, I thought it was a locked case. We will win. I'll be able to secure an acquittal. My client was placed on her defense, and she opted to give a sworn statement, which subjected her to cross-examination by the prosecution. Strange enough, the prosecution hardly cross-examined her, having heard the nature of evidence that we extracted from their own witnesses. I was then confident that when the final judgment is given, she'll be acquitted. To my great disappointment, she was convicted and sentenced to hang. She had been charged robbery with violence because a few items were alleged to have been stolen during the events that led to the killing of the deceased. And I was shattered. It struck me deep, pierced me deep into my heart. And I recall my instructing client, the brother to the accused person, coming to me, consoling me rather than me consoling him. And I told him we must appeal this decision. And he had given up. He asked me, but Mr. Advocate, we haven't even paid you for what you've so far done. We're a poor family. We cannot afford an appeal. And I told him, we will do it pro bono. We'll do it for free. The lady went into, of course, she was led away, went to jail, awaiting her appeal. And you have meanwhile put in some death row somewhere. When the appeal came up, it was a 2-judge appeal. And I argued the appeal, and the judges were able to grasp the arguments we were advancing. That if the police pathologist had stated that the deceased was dead for 8 hours when he got to the scene, it follows that the deceased husband, by the time he was leaving the house, the wife was dead. And the only people who were in the house was the deceased, the husband, and the child. So the courts found no difficulty quashing the decision of the magistrate's court and acquitting my client. On the day of judgment, my client had not come to court, but we said we are happy to take the judgment because the prison officials just mentioned that my client was unwell and they couldn't bring her from jail to court. So the judges then acquitted my client. being the excited young lawyer, I jumped into a Kenya bus, and it was bus number 15, which would take you, it was either number 14 or 15, it was 14. 15 took you to Southlands, 14 to Otiende. You could take one of the two, jump off the bus and go to Langata Women Prison. So when I got there, as usual, they would ask you to wait. I was there with my instructed client, both of us, very happy with the result. And we waited and waited. And after a while, a prison officer came to see us and asked us that the person in charge of prison would like to see us. So we went in the presence of this officer in charge. The person asked us who we were to the deceased. And I proudly told the officer that I am the lawyer and I'm accompanied by the accused's brother. And the officer then looked down and told us that our client had been taken ill the previous night, taken to the referral hospital at Kenyatta National Hospital, and that she had died overnight. That thing hit me like a sledgehammer. The first time when there was a conviction, it pierced my heart like a knife driven right into your heart. This time, I was asked myself, how can fate be so unfair? And it was sad. I then converted myself from a lawyer to part of the funeral committee to repatriate my client's remains to Uganda. And I recall the day that we were at the city mortuary. I was really downcast. And the deceased brother came and told me, Mr. Advocate, thank you very much. And I told him, but my client is dead. She doesn't benefit at all from this decision. And he told me, no. Today, I can proudly take my sister back home in Uganda and bury her as a free person and not as a convict. So, that case, one of the lessons I learned from it, and a lesson which I've applied even in my present commercial law practice or employment and labor relation, is one must be able to give their best to a case, however big or small it is. And secondly, when one is fighting for justice, one must always appreciate that there will be obstacles along the way. And indeed, those obstacles are calculated to make you give up. I always remember Churchill, never give up, never give up, never give up when you are on the right course.
Such a bittersweet ending to a case which, obviously, as a young lawyer, you took on with all, I would say, your mind, heart, spirit, and did end up being a very solemn, with a very solemn ending.